Hello friends and welcome to the lecture. So students, as we know that we are covering the parliament, and basically these are the topics that we have scheduled for the discussion under this particular series. All right. And if we talk about the topics that we have covered so far, so basically we have done with the introduction part. All right. We have done with the organization of parliament. We have done with the composition of the two houses. We have done with the system of elections to the Lok Sabha. We have done with the duration of two houses. We have done with the membership of parliament. We have done with the presiding officers of parliament. We have done with the leaders in parliament. We have done with the sessions of parliament. We have done with the devices of parliamentary proceedings, legislative procedure in parliament, joint sitting of two houses, budget in parliament. Okay. So out of 18, the 13 topics are these topics on which we have completed our discussion. And the topic on which you can say that we were discussing is the multifunctional role of parliament. Okay. And the remaining topics that we haven't started the discussion, these are the ineffectiveness of parliamentary control, position of Rajya Sabha, parliamentary privileges, and the sovereignty of parliament. All right. So this is the picture that we have created so far altogether. So basically in this lecture, we will start from where we had left in the previous lecture. Okay. So let's start. So we know basically in India, we have the parliamentary system, right? And I have told you in the democracy, when we talk about the democracy, so democracy, there are two systems, the parliamentary one and the presidential one. Okay. In the parliamentary one, the executives having the responsibility towards the legislature. Got it? While in the presidential system, basically they both are separated. It means that the executives are not responsible towards the legislature, as well as the legislature having no control over the executives. But this thing is not as same as in the parliamentary case. In the parliamentary case, the executive and the you can say the legislatures, they both having the relationship. Okay, and the executives are responsible for the legislature. And we know when we talk about the financial matter, okay, so the parliamentary control on the executives is basically exercised by the two ways. First, the budgetary control. Okay, it means that before the appropriation of grants through the enactment of the budget, the parliament having the control. Second case is post budgetary control. It means that now the money has been granted. All right. And this is called the after the appropriation of grants. Okay. And this is done through the three financial committees. About these committees, I had told you in the previous lecture also. Okay. And we know that basically in budget, based on the principle of annuity, it means that there is a budget for one financial year because of the dynamic situations. If the granted money is not spent by the end of the financial year, then what we had discussed, the balance expires and returns to the Constituent Fund of India. This will not add on to the grants of the next year to that particular ministry or that particular department. Got it? Now let's move forward. So basically this practice that we have discussed right now is known as the rule of lapse. Okay? Rule of lapse. So please remember this term in your examination. If this term asks like what do you mean by the rule of lapse, so you must be able to answer it. Okay. After this now, so basically what is the significance of these things? Like we have discussing that the money is basically granted from this, parliamentary approval is required for this, and then if the money did not spend well, then the money will return. So whatsoever is the significance of all this? Let's discuss it. So the first thing that we could see here is that it facilitates effective financial control by the parliament, as no reserve funds can be built without its authorization. It means that no executive would withdraw the funds, okay, until or unless the parliament enacts the act and authorize the executive to do so. All right, so that the corruption cases and you can say the ill management of the spending of funds could be controlled in an effective manner. All right. However, the observance of this rule leads to heavy rush of expenditure towards the close of the financial year. Okay, this is popularly called as the March rush. What does it mean? It means that, remember, whenever this is you can say the end of the financial year, most probably the March month. Okay, so what we know, suppose if the XYZ ministry is here, okay, and the 10,000 crore rupees have been granted to this. If the ministry was able to spend only 8,000 crores, so it means how much reserve has been left? 2,000 crores has been left. Okay, and these 2,000 crores will not carry forward in the another grant of the ministry for next financial year. So where does this 2,000 crores will go? This 2,000 crores will be goes back to the Constituent Fund of India. All right. So that's why to spend the money in a proper sense, there is always some kind of heavy rush of expenditures. Okay. It means that the ministry and the department which were unable to spend the money in a proper sense, they will try to spend it as much as possible before the closing of the financial year. All right. So this is popularly known as the March rush. Okay, so here we have found, you can say, the two terms. The first term that we have found is the rule of lapse. Okay, and second is the corresponding term March rush. Okay, why I'm saying corresponding? Because as per the rule of lapse, if the granted money couldn't be spent well, then the remaining amount will be go to the Constituent Fund of India, will not carry forward. Okay, so to avoid this kind of situation, there is a heavy rush of expenditure during the closing of the financial year. So that's why it is known as the March rush. So that's why they both are interconnected, and March rush is basically correspondence to the rule of lapse. Got it? Now let's move forward. After this, now we have the another thing that is known as the constituent powers and the functions. So the parliament is basically vested with the powers to amend the constitution by a way of addition, variation, or repealing of any provision. Okay, like let us discuss this thing. Okay, in a, you can say, very sound manner. Okay, there is nothing new that we are going to add. We are just only going to revise the previous ones. Okay, like I had told you, remember, this is nothing new. It is that what we had already covered. In 1950, Constitution implemented. Okay, all right. So here you can say the situations which were prevailing in 1950. These situations are not same as today's situation. First thing, okay, why? Because I have told you many times that things are not static, but they are dynamic. Okay, the things are not static, but they are dynamic. And the same thing also understood by the constitutional makers. Okay, so that's why they provided the provision of amendment. Amendment means that they had given us a way, like in the future, if any new condition add-ons, okay, and anything changes, and it feels that the constitution through which we are running our country amended, change and all. Okay, so basically, to do this kind of thing, there is a article that we have got in our constitution. Article 368 stands for the amendment that is already we had discussed. Okay, so basically these were the things. Okay, and then we know since 1950 till now there have been so many amendments. Okay, and the amendment basically done in a following way. It means to add something new. Okay, you can say when the constitution was implemented in 1950, might be the thing was not needed on that time, but over the period of time, the things of the surroundings of the environment nationally or globally got changed. Due to this, we felt that we required to add this provision in our constitution. This led to the addition. First thing. After this, variation. What does it mean? It means that basically there was a something in our constitution. All right, that particular thing was much needed in 1950, and you can say was needed basically. All right. But over the period of time, the importance of that particular thing goes down, and we felt that we are no longer required to have that kind of thing in our constitution. Okay, so what happened? Repealing of provisions and the variation of provision. It means that now we are required to repeal that particular provision. Okay, so these are the ways. Either you are adding something, modified something, or removing, repealing something. Got it? So this is the amending powers of the constitution by the parliament. Major part of the constitution can be amended by the parliament with special majority. Okay, about special majority, I have told you in the amendment of the constitution lecture, and that is the majority of the total membership of each house. Majority of total membership of each house, and a majority of not less than 2/3 of the members present and voting in each house. So you can say not only the approval from 50% members are required, but also at least 2/3 of sitting and voting members must be in favor. That is the special majority. So the majority part of the constitution could be only amended by this one. Okay. But there are other provisions also. Okay. And this could be amended by the simple majority. And the simple majority is a normal voting process, like in your classroom, in your schools, and in your colleges, you have done this. Okay. Suppose you are favoring something, that something should be done. Okay. So for this, you know that you require the more than 50% members in your favor. Similar thing is in the simple majority. It means that suppose if there is 100 members sitting and voting, and some provision is to be passed by the simple majority, then at least you can say more than 51% members must be in favor. Then the thing could be passed. Okay. Simple majority is a normal majority that we practice in our classes also. All right. Only a few provisions of the constitution, they can be amended by the parliament by special majority and with the consent of at least half of the state legislatures by simple majority. Okay. So there are three kinds of majority. Simple majority, more than 50% members must be in favor. Special majority, more than 50% member along with 2/3 members must be in favor. Thereafter, simple majority, special majority with the consent of at least half of the state legislatures. Okay, but when the provision is to be passed by the state legislatures, then the provision is not required to get passed by any kind of special majority, but by the simple majority only. Okay, so this is the thing. However, the power to initiate the process of amendment of the constitution in all the three cases, simple majority, special majority with half of the state consent, these are basically exclusively lie in the hands of parliament and not the state legislatures. So what does it mean? It means that if the constitution is to be amended, all right, then basically the parliament, which represents the central level, they only could initiate the process. Okay, state legislatures not. Why? Because if we talk about the states, so states not represents the national level, but they represents the some kind of territorial part or the regional level. Okay, so if they would have the power of amending the constitution, what will happen? You know, like they will amend the constitution as per their will. Got it? Okay, and then what happened? Uttar Pradesh will have different constitutional provisions. Rajasthan will have different. Gujarat, different. Andhra Pradesh, different. Kerala, different. So could you imagine that how will be the situation? Okay, it means that the person who is living in Uttar Pradesh, if he is moving to the Tamil Nadu, then the person would have the different constitutional provisions in the state of Uttar Pradesh and different in the state of Tamil Nadu. Why? Because the state legislatures will have the power to amend the constitution. Okay, and they will amend it as per the territorial need of their state. So to avoid this kind of variations and to maintain the uniformity throughout the country, basically that was the concept brought us by the constitutional makers that only the parliament which represents the central level, they could initiate the process and they would have the main powers. Okay, it means the exclusive powers as well as the majority powers of amending the constitution lies with the parliament itself. Okay, the organization and institutions which represents the central level. There is only one exception, that is the state legislature can pass a resolution requesting the parliament for the creation or abolition of the legislative council in the state. Okay, we know in the parliament we have the bicameral system. What is mean by the bicameral system? It means that we have the we have the two houses. Lok Sabha, the house of people, Rajya Sabha, the house of the states. Okay, similarly, the state legislatures, if we talk about the state legislatures, then the constitutionally, they do not get bicameralism. All right, but if the state feels that they must have the bicameralism, so they could do it by passing the resolution, and that resolution would only be requesting nature. Remember, requesting nature. What does it mean? It means the resolution will request the parliament kindly allow us to maintain the legislative council in the same pattern as per the Rajya Sabha. But of course, the powers will be fewer. All right, because generally the states having the state assemblies, state legislative assemblies, you can call them. All right, and if the state wants to have the state legislative council, then they could pass a resolution in their assembly in the state legislature. Okay, and the resolution will be requesting the parliament. It means that still the parliament will have the power whether they want to grant this to the states or not. All right, based on the resolution, the parliament makes an act for amending the constitution to ratify. Okay, it means that if the parliament considered it's fit, then the parliament will passing then act and amends the constitution so that that particular state will have the state legislative council. Got it? So here to sum up the things we can say, the parliament can amend the constitution in the three ways. What are these three ways? First way is by simple majority. Okay. Second way is by special majority. Third way is special majority but the consent of the half of the state legislatures. Okay. The maximum provisions could be amended by the special majority. Okay. Thereafter the simple majority, and the fewer could be amended by the special majority but with the consent of half of the state legislatures. Okay, a special majority, two things: 50% members must be in favor, more than 50% members must be in favor, and at least 2/3 of the members sitting and voting must be in favor. Simple majority, only more than 50% members must be in favor. A special majority but with the consent of half of the state legislatures, it means 50% members, more than 50% members of the parliament along with 2/3 members sitting and voting, and state legislatures more than 50% members. It means simple majority must be in favor. Got it? Thereafter we can say the constituent powers of the parliament is not unlimited. It is subjected to the basic structure of the constitution. What do you mean by the basic structure? So let me tell you one thing very straight, and you can say let me tell you a story. Okay, so what happened when in the 1950 when the constitution was implemented in the country? Okay, so basically the article 368 provides for the amendment. Okay, and we know in India there is a majority party rule. Okay, it means that whichever political party secures the majority of the votes pooling, okay, they will have the power to form the government. So they will form the government, and if they secured a majority of votes, it is obvious that they will have the majority of the seats in the Lok Sabha and the Rajya Sabha. Okay, so if any you can say amendment procedure would be presented in the parliament, because the ruling party is having the majority, it is you can say very easy that they could easily amend the constitution. Okay. And if the amendment is favoring their political interest, then this thing is highly dangerous for the protection of the democracy, right? That will be the thing. So basically, you can say in the starting, various provisions of the constitution was amended. Okay, was amended in a way that they were favoring the government and they were favoring the central government basically to do the things. All right, and even the parliament in a particular, that they could easily do the things without the constitutional barriers. Okay, and this thing continued for a long time. And basically during this time, various you can say the contraventions between the parliament and the judiciary happened. All right, but still there was a no doctrine and there was no formal thing to put an end, and you can say to put a cap on the amending powers of the parliament. So this thing continues for a long. Okay, and then what happened in 1973? Basically, that was the year of 1973. There was a case that came to the Supreme Court, and the case is known as the Keshavananda Bharti case. Okay, in 1973, when the Keshavananda Bharti case came to the Supreme Court, all right, and we know the Supreme Court is designated as the guardian of the Constitution. Okay, so it was on the Supreme Court how to protect the Constitution and all. All right, so basically on that time the Supreme Court formulated a doctrine. That doctrine is famously known as the basic structure doctrine. Okay, and in the other words, in the you can say simpler words, you can say basically the amendment powers has been granted to the parliament. The parliament could amend the constitution, but this amendment is subjected to the basic structure. It means that the basic structure of the constitution that could not be changed. All right, only the provisions which are not formulating the part of the basic structures, they could be amended or changed, but the provisions that are forming the part of the basic structures, these could not be amended, these could not be changed. Okay, so from 1950 till 1973, the concepts were going on, but in the 1973, for the first time, when the Supreme Court was hearing the Keshavananda Bharti case, they had formulated what we call today is the basic structure. Got it? So in the other words, we can say the parliament can amend any provision of the constitution except the basic features. The features which formulates the basic structure of the constitution, and you can say which are the base of the constitution. Got it? So this was ruled by the Supreme Court in the Keshavananda Bharti case 1973, the same I have told you. Okay, and reaffirmed in the Minerva Mills case 1980. It means that in the Keshavananda Bharti case 1973, the Supreme Court first proposed the concept of basic structure, and basically that was clearly defined and modified in the Minerva Mill case 1980. And why it's so? Let me tell you one thing very straight. If we talk about the Supreme Court, judges changes over time. Okay, situation changes over time, and the interpretation of the Constitution even changes over time. So if you do a little bit research by yourself, if you are curious about it, then you can find if the one judgment passed in one case, okay, then there are highly chances that this judgment would be changed in the another case. Okay, because the reason I have told you, the judges has been changed over time, the situations have been changed over time, and even the interpretation of the constitution changes over time. Okay, so that's how the things goes on. So students, basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and keep yourself ready for the next lecture. With this note, let's end this lecture, and what we say thank you.